Good morning, ladies and gentlemen. My name is Natarojit Sopa. I'm a third-year student from Faculty of Law, Thaksin University, Songkhla campus. I really appreciate and honor to be here as MC for today's event. The e-cultural exchange program is a good opportunity that we can exchange each other between many countries about any aspect of law. For our group, we would like to present about leave in labor law. Of course, for this topic, we have many special guests. Let's start. Good morning, Mr. Ismail bin Salat.
Good morning, everyone. For the topic of leave have many details. I will talk about sick leave first. Sick leave in Section 5 means in the Labor Protection Act 2541, employees are entitled to sick leave as long as they are actually sick. So, in this word, mean any employee is sick to the extent unable to come to work as usual, need to take time of work to rest, or get medical treatment until the ailment will go away. In case the employee is unable to work and has to stop work due to injury or illness incurred due to work under Compensation Act 2537 and maternity leave under Section 41 of Labor Act 2441 is not legal as being sick to take sick leave under this act. In addition, I would like to talk about necessary business leave for this topic. Employees are entitled to leave for necessary business for not less than 3 working days per year. The term essential business refers to an obligation of task that must be performed or performed by oneself, which can be a problem if the employer strictly adheres to the meaning of the term and use a permission system of approving or legally reviewing leave will cause problems of dispute between employers and employee. Thank you.
Thank you very much for the information of sick leave and necessary business leave. The next topic is concerned about leave for sterilization and military service leave. I would like to invite Mr. Padungkiat to be lecturer.
Good morning, everyone. For the rule of law about employees have the right to have sterilization and have the right to leave due to periodic sterilization, term specified by a first-class modern physician, and a certificate issued by the employee is also entitled to receive wages on that day of leave in accordance with Section 33 and 57 of the Labor Protection Act BE 2541. Moreover, Thai labor law also states about military service leave. Employees have the right to leave from military service to summon troops for inspection of military training or to test the readiness by taking leave equal to the number of days the military call and receive wages throughout the leave but not more than 60 days per year in accordance with Section 35 and 58 of the Labor Protection Act BE 2541.
Thank you, Mr. Padungkiat. We would now to invite Mr. Anantamet to present the topic of leave for training or development.
Well, for this topic, according to the Labor Protection Act 2541, Section 36 states that an employee shall be entitled to take leave for training or the development of his or her knowledge and skills in accordance with the rules and the procedure prescribed in the Ministerial of Regulations. The way to take leave for training or development. The employee must notify the employer at least 7 days in advance, specifying the reason for excess leave, including the presenting evidence of the request for leave. The employer may not allow the employee to train or develop knowledge if 1. In that year, employees were allowed to take leave for training has been in that year for a total of 30 days or had leave three times. 2. If the leave may damage the employer's business operation and the employer can prove damage. In this point, the law gives the employers the right to refuse employee to participate in trainings, such as working in important positions. If the work stops, it may be interrupted or damaged, or the work urgently lack of people do not have to work continuously, etc. That's all I would like to present in this topic. Thank you.
Thank you, Mr. Anantamed, for good information. The next topic is concerned about maternity leave. I would like to invite Ms. Arya Ratanapidom to be presenter.
Thank you, Ms. Natharot. According to the Labor Protection Act, BE 2451, Section 41, Amendment Number 7, on 2562, employees maternity leave. Right law states that pregnant female employees means that all time of employees who are pregnant women are entitled to maternity leave under the Labor Protection Law, without limitation whether the employee is full-time, employees, temporary worker, or probationary employees, etc. You know, the law says that pregnant female employees is entitled to take maternity leave as soon as she becomes an employee, regardless of the type of employees or have to go through probation or not, even she works just 1 day. Employees' right is to 98 days of maternity leave, but pay only covers 90 days due to applicable laws stipulate that the employer is obliged to pay wages throughout the period of time the employee has been paid, but not more 45 days. According to the labor law, BE Section 59, with the other half of the wages the employee receives from the Social Security Office of 90 days of average wages, it can be seen that the number of 8 days of leave increases. Employees are not covered for wages. Do you have any idea about this topic?
Thank you very much. Yeah, I also know that the amount of days for maternity leave was extended from 19 to 98 days. It's more protection for female employees. Well, ladies and gentlemen, on behalf of Faculty of Law, Thaksin University, Thailand, thank you so much for your intention to listen our group. It's been our pleasure to present and exchange any aspect to all of you. And we wish you all a pleasant day.